So how do you deal with really small probate estates? You've either just talked to a lawyer or you know it's not going to make sense to work with an attorney because the fees are just too high. In these kind of situations, you've got to look at the value of the property. Hi, my name is Dan Schnurbush. I'm an estate and probate attorney based out of St. Charles, Missouri, and we help clients all over the state of Missouri deal with the death of a loved one through the probate process in court, okay? So there's a couple of ways to deal with really small estates. So there's different cutoffs in the state of Missouri. So the first one is the small estate threshold. Anything under $40,000 when you have a total estate value net of debts and expenses that is less than $40,000, you can qualify for small estate treatment and you can file a small estate affidavit. And we will deal with that in more detail in other videos. But in most counties, you're going to have to hire an attorney for a small estate affidavit. Depends where you're at. In more rural counties, it's less likely that you'll have to have an attorney. St. Louis City, St. Louis County, you're definitely going to have an attorney to file a small estate affidavit. But what if that doesn't make sense? What if what you found is like a $2,500 bank account or a 2001 Toyota Camry with 250,000 miles on it, and it just doesn't make sense to spend a couple $1,000s on a lawyer to go through the probate process? Well, what are your options? Okay. Well, unfortunately, there aren't a lot in the state of Missouri, but there are a few things that you can do. One is if you are the surviving spouse of the deceased, you can file what's called a spousal refusal of letters application. And in general, you can file this in almost every county without an attorney. And that will generally work when the value of the estate is smaller than about $20,000 to $24,000, depending on what county you're in. In St. Louis County, it's about $24,000. In St. Louis City, it's about $20,000, but it really varies from county to county. And if you have a copy of your income tax return or other things where you can show that you depended on the deceased for more than that amount, the judge may or may not allow it to pass even above those thresholds. So if you are the surviving spouse, you may be able to file a spousal refusal of letters application by yourself. And I'm going to show you how to do each one of these in just a minute. If you are a minor child of the deceased or the surviving parent of a minor child of the deceased, and we're not married to the decedent, you can file what's called a minor refusal of letters application. And then there's three different kinds of refusal of letters applications. Essentially what a refusal of letters application is it's the judge saying we're not going to grant letters of administration or letters testamentary here because one of these three conditions is met. Either it's the spouse filing, a minor child filing, or a creditor filing. So it's the same as with a spouse. When you're dealing with a minor child, it's the same as with a spouse. Has to be below a certain amount. The child has to be a minor. But if those conditions are met, often you can file without an attorney. The last method that applies most commonly is when you have a creditor of the deceased. Usually it's like an adult child who paid let's say a funeral bill or a headstone or cremation bill or something like that, and is trying to claim the asset of a deceased that's a small asset, like a little bank account or an old car or something like that. We run into this a lot, okay? So if you are falling into one of those buckets, most commonly it's an adult child, but it could be anybody. A creditor doesn't even have to be an heir. They merely have to have spent money on behalf of the deceased's estate, taking care of their stuff. Most typically, you're only going to be able to get it to go through if it's for a funeral bill or a cremation bill or a headstone bill, something related to the actual funeral and burial. In many counties, they're not going to allow a creditor refusal to go through if it's for a different or lower priority creditor claim. But if you have any of those things applicable, this might be the option for you. So let's go through and see how you would find and file these refusal of letters applications. So ultimately, it's going to depend on your county, but you're just going to go to Google, type in whatever your county is, St. Louis City, St. Louis County, St. Charles County, Jefferson County, whatever county you're in, wherever the deceased was living and the deceased's asset is located. And this isn't going to work for real estate. Refusal letters applications, especially for creditors, are not going to work for real estate. It might work for spouses and children, though. In fact, they often do for spouses and children, but not for creditors. So what you're going to do is type in the county, then type probate forms, all right? And then hit search. You'll see in St. Louis City, the top hit here, it says court forms. This is where you need to go. We're going to open this up. You'll see this nice page for court forms. Scroll down to probate decedent's estates, refusal of letters, and then you'll see there is a control find creditor application for creditor's refusal. You're going to crack this open and you'll see the St. Louis City form. This is a free form online. Here's the checklist. Here's the link to the filing fees that you'll need to pay to file and all the documents you're going to need. In general, you're going to need the death certificate of the deceased. You're going to need verification of the asset. So if it's a bank account, you're going to need to get a bank statement. In order to get a bank statement, you might need to subpoena that bank because they may not be willing to produce a bank statement without a subpoena. You'll get a subpoena from the courthouse. Okay, you may be able to find it here online, but you can certainly get a subpoena. Oh, here's one, subpoena. You Google this form. You can use this subpoena on the City of St. Louis website and fill this out to produce the following papers, documents, and then you're going to say bank statement for Jim Smith, decedent, social security number, date of birth, April 1st, 1975, right? So put in that information so they can actually locate who you're talking about. Once your probate case is filed, you can take this subpoena and provide it to the bank where you're trying to get that asset. It really depends on what county you're in. This is the St. Louis City one. This has been signed by Commissioner Hanley. And at the time you're watching this video, Commissioner Hanley may not even be the commissioner at that time. So check with your probate court to see if they have a specific subpoena form that is pre-filled that you can use. And if they don't, you'll need to get one filled out and signed by the judge before you can take it to the bank. But a lot of people get stuck. They're like, the bank won't give me a bank statement and the judge won't give me the order. So how am I supposed to go? You have to get a subpoena. Subpoena is a court order to produce a document or a statement from a third party, in this case, the bank. Okay. So you'll need verification of the asset, the death certificate. You're going to need verification of the debt. So if you paid for a funeral bill or something like that, you're going to need a paid receipt or something that shows that you paid that funeral bill or that creditor or that cremation bill or something like that you can provide to the judge. Okay. And they list all this out in detail, everything you need in the City of St. Louis. But you can see the form for a creditor refusal of letter, very simple, just a few boxes to fill out: estate of the deceased, your name, date of death. You can sign it. There is a place for an attorney, but in general, you do not need one. In the St. Louis City, they will accept them without an attorney. Exhibit A, you're going to fill in what the property you're trying to claim is. So real property, this is not, in many places, they're not allowing real property to pass under a creditor's refusal. This is just their generic Exhibit A. But personal property like bank account, car, stuff like that, you will list that on here. If it's a car, you're going to need the VIN number. If it's a bank account, you're going to need the bank account number and the balance. And in many cases in the city, they're going to want to see a bank statement as proof of that as well. Okay. So that's the St. Louis City creditor refusal form and the subpoena form that you can use. All right. And if you are a spouse or minor child, let's see, do we have these statement of survival, application for spousal refusal? Here we go. So you can see it's very similar. We need basically the same stuff. It's just that you're claiming as a spouse instead of a creditor of the deceased. And the limits on these are a little bit higher. Something I forgot to mention, the limit on a creditor refusal is $15,000. So if the estate is over $15,000, a creditor refusal will never work. But if it's under $15,000, it might work if you have a qualifying creditor bill. Okay. But you can see it's basically the same application. You're just filing as a spouse instead of as a decedent. Now, when you're filing as a spouse, you don't need to prove any debts of the estate because you're filing under your rights as a spouse, as a surviving spouse. You are not relying on a creditor claim or anything like that. So that is how you would find that. Now, you can do that for any county. Like if, let's say, Google St. Charles County probate forms, you can see they have a button down here where you can click probate and it will take you over to I can get it to open. I don't know why the button's not working, but it will normally open a Google Drive folder where you can find the forms and download them. St. Louis County is very similar. Let's say St. Louis County probate forms. Once you have these completed and you have all the supporting documentation, you are going to call the county's office, credit refusal packet in St. Louis County. Here we go. You can see it's very, very similar to the St. Louis City. You've got some instructions at the top. You've got a table of contents of the documents contained in the packet and a more detailed checklist of everything that you're going to need to file. Confidential case filing info sheet. If you're filing pro se without an attorney, you will also need to prepare this case filing info sheet, no matter what county you're in. You can get a copy of it for free online. If you just Google Missouri case filing info sheet, this takes you to the master Missouri list of templates for the entire state of Missouri. And you have a couple of here. Let's see, do we have confidential info sheet for probate and non-domestic relations. Here's an example one you can use statewide. And that's the big stuff, right? You need to find the correct form for your county. If your county doesn't have one, if nothing comes up on Google when you search this, you can still search for Missouri creditor refusal packet. And I believe that Missouri I think this is the statewide one. This might be Circuit 13. But if you can find any template with instructions, Jackson County also has very good templates and very good instructions for pro se filing. Theirs also contains the redaction certification, which technically you're supposed to file. I think they'll accept it without it. But Jackson County in Missouri also has very, very good forms for everything, okay? So check those out. See if you can find a form in your county. And if you can't, go to a different county. Jackson County, St. Louis County usually have very helpful forms with very helpful instructions. The basic filing requirements and documents required to prove up your case are going to be the same in every county. So do your best to run with it on your own if it doesn't make sense in your situation to hire an attorney, right? So again, this is for people who the value of the asset they're trying to claim is too small to justify hiring an attorney. And they also fall into a couple of different buckets. You're either a surviving spouse, a surviving minor child, or a parent of a minor child, or you are somebody who has paid a debt or bill for the benefit of the estate, namely that funeral creditor, or the funeral bill, the cremation bill, the headstone bill, something like that. If this was helpful, leave us a like and subscribe down below so that other people can find this video and help answer their questions. But that's it for this video, guys. I'll see you on the next one.